Hello and welcome to Ravlic at Large. My name's Tom Ravlic. Thank you for joining me for the second episode in season 2 of the program. Let me put a proposition to you, a hypothetical even. You get a bit excited because a politician says something on television. You write something particularly clever, in inverted commas, and you are pretty happy with yourself. Your friends online, your followers online start to circulate this piece of material around the place. And they're equally amused by what you have said. But what is it that happens when somebody affected by those words looks at that material that you've been so entertained by and has gradually become viral over 1 day, 2 days, 3 days, and 4? And what are the risks to you in relation to legal action, particularly defamation, when you engage online and somebody takes exception to what you've said about them? The managing partner of Mark Lawyers, Michael Bradley, joins me today to talk about the kinds of risks that you might face if you get particularly robust in your language and somebody feels that you have defamed them. So Michael will take us through some aspects of defamation law and provide some guidance as to what you need to think about before you hit the post button. Michael, thanks for joining me for this particular episode.
My pleasure.
Now, it's always useful to get a foundational question out of the way. When we talk about defamation, a term that some people might only encounter when they read the press themselves, what are we talking about here?
Yeah, so defamation is what happens when someone publishes something or broadcasts something or says something that attacks the reputation of another person in a way that is likely to cause other people to think less of them. That's the really broad brush definition of how someone is defamed. So it is broad, but yeah, if you sort of think about it in terms of slurs and not so much insults, but bad things that people say or write about each other, then that's the field of defamation.
In order for someone to be defamed, it does need to be published. Is there a difference between modes of publication in terms of the severity of how defamation may be viewed, how an attack on someone's reputation may be viewed?
Yes. So yes, there has to be publication. It has to be, so you can't defame someone only to their own face. So, if I write you a letter and call you names, and you're the only recipient of that letter, then that's not actionably defamatory. But if I write a letter to another person about you, then that is a publication of the defamation, and it need only have an audience of one. However, the extent of publication and the form of publication has a big impact on how much damage is done. So, if you broadcast to the world, then obviously the impact is much bigger. So that will ultimately reflect in the size of a damages award if the case is successful, but it also has quite significant implications under our defamation law for whether you can bring a defamation case at all, and that's sort of one of the technical aspects of the law. But yes, certainly there's high relevance to what form of publication and how wide it goes.
you mentioned the notion of a letter, which is a very basic form of communication, typically only to a particular audience. If we say person A and B are writing to each other, and it's a direct communication. If you write, the person A writes to person C about person B in negative terms, that's a defamation.
Yeah.
If somebody scans that letter and then puts it up on the internet, by Rex, for example, what person A writing to person C and defaming somebody is a limited audience.
Mm-hmm.
Some person C potentially scanning a document and putting it up online. What happens? Are we talking the concept of aggravation, or are we just talking the concept of a broader audience to which the defamation goes?
Well, it might have a number of implications. In that hypothetical, that may be a problem for person C, not person A, because if I wrote a letter to your employer about you and said, Anthony is a thief, and that's so that's my publication to your employer, and that's defamatory of you, then yes, that's actionable against me at your hands. But if your employer then chose to publish that letter on the internet or that email on the internet and give it to the world at large, then that's not my problem. That's his problem at that point, because he's the one publishing in that medium. So publication can happen in serial form. It can happen in lots of different ways. Each publication is independent, and the people who are liable for the publication are the people who do the publication or are involved in the publication. So if in that hypothetical, if your employer published my letter on the internet without my consent, then I couldn't be liable for that and the consequences of that broader publication. But if I had given him permission to do it or encouraged him to do it, then yes, I may be seen by the courts as being involved in that publication and therefore liable. So, you can see, like, it can get very technical very quickly in terms of liability and what the consequences are of different forms of publication. But yeah, the sort of the main principle is whoever does the publication or causes the publication to happen is the person or persons who are liable for it.
Now, publication, we don't just say publication means words. Sorry, in the written word, it can be the spoken word. It could be digitally altered imagery, couldn't it? In this day and age,
sure, it could be anything. Yeah,
could be anything that impacts on someone's reputation.
Yep, it can be a cartoon or a photo or a drawing. Yeah.
Okay. So when anybody is thinking about their use of, say, social media, X predominantly, I guess, LinkedIn even, they need to be wary of anything that is particularly, I guess, to use the word colourful and negative, could have implications, don't they?
Yeah, that's right. You have to be mindful of who you are speaking to, like how big an audience. You've got more safety in a private Facebook group than you do in a public one, for example, because that goes out to the world. The rule of thumb in terms of what is defamatory is to think about it, is to understand that defamation is judged not according to the words that are published or the image that is published or the words that are spoken, the literal form, but the meanings that those words or images convey. So defamation is assessed on meaning, not on the literal definition, which means that you can defame someone between the lines. You can defame them by implying through how you express yourself or what you publish, implying something negative about that person without necessarily saying those explicit words. And it's probably the most complex aspect of defamation law that generates the most controversy in cases, is the argument over what the meanings of something that's been published are. We describe in defamation law, they're described as imputations. Okay. The defamatory imputations. And if you sue someone for defamation, you have to define the defamatory imputations that you say were conveyed by what the person published about you. And those imputations will be different usually from the specific words. So, for example, if you publish a cartoon about someone dressed in a black uniform with a black cap and a red armband doing something hideous, the defamatory imputation that's likely to arise from that is that you've called them a Nazi, although you haven't used the word. And that that word appears nowhere in the cartoon, but the imputation is clear. You are calling that person a Nazi, and that's a defamatory thing to say about someone. So that's it is complicated and very controversial.
Publication has been democratized by the advent of social media and where social media has taken us. So in the case of years gone by when you and I had fewer wrinkles and all of that stuff, the mainstream media publications, so the television network publishers, television networks, newspapers, and radio stations would have had lawyers attached to them or working for them to keep track of what it is that is being said and assessing the risk of defamation action. Mm-hmm. What has happened, in your view, with the advent of social media and the opening up of the opportunity to publish to people who may not have legal training, but they have the same power of publication now as, for example, a journalist working for The Australian or The Age?
Yeah, it's had dramatic impact because, everyone is a publisher now. Anyone can go online and broadcast their opinions or whatever to a very wide audience, to the world. And I think for a long time, most people have operated under an implicit assumption that the internet is not the real world, and the law that applies in the real world doesn't apply on the internet, which is true to some extent. But it's kind of a free space, like it's a sort of an unregulated world where you can do things you can't do in your normal life. You can say things about people or to people that you would never say about them or to their face offline, and there are no legal consequences to it. And that sort of bred this idea of anonymous impunity from consequences, which is why social media is such a sewer. The legal fact is that the law applies on the internet just as much as it does anywhere else. So defamation law applies, and you can be sued for defamation for things you do online. And that led to an explosion of defamation litigation in relation to social media. So people suing each other for things they'd said on Facebook, etc. If you go back a few years, in Australia, the courts were becoming rapidly clogged with online defamation cases, so-called Facebook disputes. some of the most recent law reforms in that area have been designed specifically to reduce that deluge of litigation. And so a new threshold test was introduced, which is called the serious harm test, which says you can't sue for defamation at all unless you have suffered or are likely to suffer serious harm to your reputation because of the defamatory publication. And that cuts out the vast bulk of these sort of petty Facebook disputes, and has made it harder to get to bring a case forward. So that has reinstated some of that impunity, and it means that people actually do have more liberty to say or write defamatory things about each other online. It doesn't manage the risk in the sense that when you go online and publish something defamatory about someone, you don't actually have any control over how much damage that's going to do. So you're taking a punt on it, and a big part of that punt is how viral is it going to go? Because if you post a comment, for example, on social media, it can be shared, it can be liked, it can be, it can go viral out of your control, and that can lead to what you described as aggravated damages, where what's called the grapevine effect happens. So something starts small and then goes big through going viral, and that can all come back on the original publisher, and take them easily over the serious harm threshold, even though they thought they were just having a little dispute in a little forum. So it's still dangerous, and like I say, it's an unmanageable risk. It's still a better idea to not defame people.
And that last part of what you said is probably best expressed in the old school saying, isn't it? If you can't say something nice, say nothing at all. Yeah,
but I think that there are ways around this in terms, if you want to actively participate in a public debate, say you started with you think you've got something clever to say about a politician, you can do that in ways that will not expose you to significant to legal risk. And there are a number of sort of principles that help here. One is that if you target a person's actions rather than their person, then it's a lot more difficult to be defamatory. So if if a politician says something that's tells a lie, then you can call that out, and that's not defamatory. But if you call them a liar, then you're attributing something to their character, which is defamatory, and you're going to have to make that good. But you don't have to go that far, and it's not actually a particularly useful contribution to the debate. Likewise, drawing a distinction between someone saying something that's racist and labeling them as a racist. It's also important to understand that there's a lot of leeway in humour. So if you have a go at someone in a satirical way, so you satirise a politician, for example, a public figure, then again, it's much more difficult for that to be actionably defamatory, because defamation is judged in the eyes of the audience, and it's only actionable if what you published was likely to make the audience think less of that person because of the defamatory thing you said about them. But if you were joking and it's self-evidently humorous, non-serious, then that's how the audience is likely to receive it. It's a joke. Not that it's, not that it can't be defamatory, but it's safer ground.
So we're still allowed to be funny, but we need to be careful how we're trying to be funny.
Yeah, and there's also a distinction drawn in the law for what's called vulgar abuse. So if you just call someone, a rude word, that's not, again, because nobody's going to receive that as a statement, as an assertion of fact. You call
Right.
someone, you say, "Oh, that person's the C word." Nobody actually, from that is going to take that, you are calling that person that anatomical, body part. It's just abuse, and that's not actionably defamatory.
Well, there are a couple of C words that come to mind. One is stat, and then if you were talking about another C word being corrupt, you're talking about a characteristic and a manner of character, right?
Yeah, and then there are things where they're just inherently defamatory. If you call someone corrupt, yeah, it's defamatory. If you call them a rapist, that's defamatory. If you say they're an arsonist or a criminal, those are they're inherently defamatory things to say about a person. So if you accuse someone of committing a crime, that is going to defame them, and the only possible defence for that is truth. So you're going to have to be able to back that up as an assertion of fact. Otherwise, it's indefensible.
It may be useful to touch on just briefly, because the literature in the area of defences against, or possible defences in the case of defamation, is deep and wide, etc. What are the kinds of things that people need to understand about how to defend a claim?
Yeah, because the defence is usually the biggest piece of the case. Like, it's not actually that difficult to defame someone, and so the plaintiff's job is relatively easy. They just have to identify something that you said about them that was defamatory, and then their part of the case is over. But as the defendant, you then have a range of defences available to you, and that's where most of the fight tends to be. So yeah, the principal defence is truth. Truth is a complete defence to defamation. If you've said something about someone that's defamatory, but it's true or substantially true, then you have a complete defence, and the plaintiff loses.
Okay.
So you're always on safe ground if you can prove the truth of what you're asserting. There's a defence of honest opinion, which gives you the freedom to express opinions about things. So, for example, a politician, you can express your opinion about them, but it has to be solidly based in truth. So, and the facts on which your opinion is based also have to be published, so that the audience can see the whole picture. So you have to actually lay out your evidence to support the opinion that you're expressing. So if you want to express that, and there's a lot of controversy in a lot of cases around what is the distinction between an assertion of opinion and an assertion of fact, because that can be quite grey. So in real terms, the opinion defence tends to be quite hard to get up, but it is viable in some contexts.
It's available in any case.
Yeah, there's a new defence, or newish defence, of public interest, which is quite a strong one. It's still in development in terms of how the courts are viewing it, but it allows you to make defamatory assertions about someone in a context where you don't have to prove the truth of it. It doesn't even have to be true, as long as it's a matter of public interest, and you had a reasonable belief that it was in the public interest for you to publish what you were posting. That's a far more viable defence for the media, like mainstream media, than it is for punters on social media. But in theory, at least, it's available. And then, there are other more exotic defences that aren't going to be much help to the man in the street.
There's probably no truth in that. But if we take one step back from the technicalities of law, which we've touched on quite well. What are some of the things people need to think about when they're using social media as a user before they write something or repost something? What's the most fundamental question they need to ask themselves?
I think, as soon as you're contemplating posting or reposting something that identifies a person, an individual, and is going to convey something about that person that is negative, then you are in the field of defamation, and you need to be thinking carefully about what you're doing and whether you're taking on a risk you don't need in posting or reposting that thing about that person, because it's not a free swing, and they may not take it kindly. Bearing in mind, as I said, you have very little control over the spread of what you're posting. The only thing you do control is what you choose to post, and so kind of think about it from the perspective of the person you are talking about, and how are they likely to react to what you're saying about them.
The other thing that's interesting, and just what you said in terms of reposting, and we mentioned this earlier, phenomenon of virality. There is a practice, and it's important we touch on this. There is a practice of people screenshotting posts so that an individual doesn't get the analytics boost from something going on. That doesn't change anything in defamation, does it? If it's particularly nasty, it's been screenshotted and it's being kicked around, it could land a lot of people in some serious trouble.
Yeah, and the point there is that when you publish something, you're putting it out there. Like I say, if I sent a private email to one other person, then I have a reasonable expectation it's not going to go any further than that. And if that person chooses then to send it out to the world, that's not on me, that's on them. Whereas if I post something on the internet, even in a private chat group, I am putting it out there on a medium and in a context where I cannot reasonably expect it's going to stay within that, that circle. Like, there's a high probability someone's going to repost it, screenshot it, like that's a risk I take, and the law will hold me accountable for that. It's a really important thing for people to understand that it's dangerous.
So, in brief, if I could sort of summarise what we've said, in an environment where communication happens at hyperspeed, it's probably best to put the brakes down.
Well, yes. I mean, I think there's a lot of merit to the practice that I implemented many years ago in the early days of email, after sending a few intemperate emails myself, of just anytime I type an email in high dudgeon or in an emotional state, I type it and then I park it for at least 10 minutes and then I go back to it when I've calmed down and then I delete it. Because the immediacy of social media, the speed of of transaction and of conversation, and that sense it
Yep.
generates that it's all in a bubble and you're safe is very dangerous, and it encourages all of us to park our rationality and circumspection and do things we would never do if we were standing in a circle of people physically talking. It's good to take a breath.
Michael, you've been very generous with your time, and we've covered a lot of ground in about 30 minutes. Where do people go if they want to know more about you and the firm?
They can come onto our website, marklawyers.com.au. We do a lot of work in this area. Always happy to hear from people.
And you've also written some stuff from time to time people will see online about defamation, haven't you?
Yep. I have a lot of stuff published, particularly on Crikey, about various high-profile defamation cases and trends in that area of law. Yep. It's always topical.
Michael, thank you so much for your time, and I appreciate the insights. And I know people who view this are going to probably be a little bit more circumspect about, to use the vernacular, slagging someone off online. So thank you.
Yeah, it's my pleasure. Good to talk to you.
And that brings this particular episode to a close. As Michael said, please be careful when you engage online. If you're not a part of a major media organisation, you don't have access to lawyers who will look at everything you write. So be conscious that is an environment we are all in, and be careful. But that doesn't mean you can't communicate. It does mean you need to be a bit more cautious about the language you throw around. I'll be back on YouTube and LinkedIn with another episode of Ravlic at Large, but in the meantime, stay safe and look after each other.